Welcome to Liberty Law Talk. This podcast is a production of the online journal Law and Liberty and hosted by our staff. Please visit us at lawliberty.org, and thank you for listening. Welcome to Liberty Law Talk. I'm your guest host, John Grove, managing editor of Law and Liberty. Over the last few weeks of the recently concluded term, the Supreme Court handed down one blockbuster decision after another on issues including religious liberty, guns, the limits of the administrative state, and of course, abortion. The decisions have sent shockwaves through the political system, and many are saying that this term might go down as one of the most important turning points in the history of the court. To help us wrap our head around these monumental decisions and to think about what they portend for our constitutional system, I'm joined by John Mcginnis. John Mcginnis needs no introduction to regular listeners or to Law and Liberty readers. He is the George C. Dix Professor of Constitutional Law at Northwestern University. He's a contributing editor at Law and Liberty. He's also one of the nation's leading authorities on originalism and is the author of Accelerating Democracy and, with Mike Rappaport, Originalism and the Good Constitution. John, thanks for joining us.
Delighted to be here.
Well, let's start by considering briefly the term as a whole. Obviously, we've been looking forward to a lot of these cases for a long time. They've dominated the news, especially after we got the Dobbs leak. When it comes to the future of originalism, our constitutional order, our political culture, how consequential do you think this term is, broadly speaking? How big will this year look 10 years from now, 25 years, 50 years from now, in your estimation?
I think this term is a pivotal change. It's a change of the paradigm of constitutional law. So I think it may be regarded as a key term 100 years from now. It certainly is the most important term since I've been teaching constitutional law, and that's 30 years. I think certainly since I've been following at all constitutional law, which is certainly 40 years. The reason it's so important is that for a long time, there have been originalism has been arising in the academic world, in circles of, I certainly think, in political circles among Republicans. But it's only this term, when there's now a 6-3 majority on the court, that we see this paradigm shift. Almost all of the decisions are driven by originalism. We can talk about how they're driven by originalism. Some are much more explicitly driven by originalism, the Bruin case, but others have originalism clearly in the background that are driving the court to go as far as it thinks it can towards a more originalist understanding of the Constitution. The methodology of the court is also completely different, and really it's very useful to compare it to the methodology of the Warren and Burger courts. If you look at the opinions, they're just not written in that way. They're written with a focus on the text, on deriving matters from originalism. Sometimes we'll talk about in the West Virginia versus EPA case, a bit of a slalom from how they derive it from originalism. But they're all originalism generated by our original Constitution. And so that is a striking fact. Now, there are still issues to be addressed by the court. While this is a paradigm shift, it's not the last word. And the biggest issue, I think, for the court is how it's going to deal with precedent, the match of non-originalist precedent on the court. We saw a variety of strategies this term to do it, but I think we're going to hear a lot more about that going forward. But it cannot be underestimated how important this is in the methodology and therefore in the results. And it makes a big difference to our constitutional order, because our constitutional order has been generally, I think, an evolving kind of common law constitutionalism, which has been moving slowly, incrementally, and sometimes quickly, I think, to the left of the political spectrum. And I think the Constitution itself, the original Constitution, while it's not a libertarian document, is a charter for a kind of classical liberalism, and therefore it has political results as well. and political results in the sense that this is a constitutional order that is much more friendly to classical liberals than the evolving constitutional under liberal justices. Moreover, one point I would make is that here we have the Supreme Court speaking on behalf of this order, being what has been called a Republican schoolmaster. And that's very important in our culture because, of course, most of our cultural reasoners, as it were, academics, the press, lean to left liberalism. And suddenly we have a voice speaking through the Constitution that is necessarily speaks in a more classical liberal key if it is going to be an originalist court. So that's a broader effect of the Supreme Court. And I think that's one of the reasons that the current court has gotten so much attack. In some sense, it's not only changing constitutional law, it's changing the monopoly, or at least the very strong tilt to left liberal discourse, because it's a reasoning institution, just as academics are supposed to be.
Okay, yeah, let's get into some of those issues when looking at the particular cases. Let's start with the two free exercise of religion cases. Two important ones that expanded our understanding of the free exercise clause, and both of these in kind of the classic religious context, the context we've seen a lot of religion cases as in public schools. One of these requires school choice programs to cover schools that might use those tuition dollars towards a kind of religious curriculum. And one of them held that it was a violation of the free exercise rights to fire a public high school football coach for praying privately on the football field after a game. So what's the context of these cases? Both of these cases also tell us a lot about the Establishment Clause, not just the Free Exercise Clause, as you pointed out in a good essay for Law and Liberty a couple of weeks ago. Both of these talk about both the religion clauses. So what's the context of these cases, and what's their ultimate
I think the
importance?
context of these cases, again, the question of whether there's a tension between the Free Exercise and Establishment Clause. I think for a long time, there seemed to be a tension, and that is cut back on the Free Exercise Clause, made it look a little different from the exercise of other constitutional rights, because it is thought that the state may have a compelling interest in enforcing a kind of separation of church and state. And while this separation of church and state is not discussed directly in these cases, what is notable in the majority opinions is how that has disappeared. It's very notable in the dissents that they say, well, this is really undermining the separation of church and state. And this is why I think this is part of the originalist theme, is the separation of church and state is not an originalist principle, as opposed to the Establishment Clause, which is worried about establishing religion. And there's been a lot of work written on the Establishment Clause, showing how it's very different from an idea of separation of church and state. It's really concerned that religious dissenters would be eliminated, wouldn't get as good treatment as other religions. And of course, to give an example of the school choice program, in some sense, by not permitting religious schools, or at least religious schools that were sectarian, that were kind of strongly religious, one actually was precluding dissenters, as it were, from public life. So the originalist take, which I do think is in the background of these cases, it's written by John Roberts, who's likely to be more a doctrinalist, but there's still a background in what disappears in these cases, is strongly, I think, connecting the Free Exercise Clause to a more constrained view of establishment. And so once one has a constrained view of establishment, it becomes pretty easy. This case becomes a pretty easy case because in general, it's pretty obvious that states cannot condition the receipt of funds, for instance, on your not teaching what you like about the First Amendment, or what was something about American history. They couldn't do that and say, well, we only like certain schools that do that. And so once you get rid of this special concern about establishment, about separation of church and state, it's easy to say you can't condition funding on people giving up their free exercise rights, their rights to talk about religion, have a religious perspective on education. So I think the key in these cases is actually the cutting back of the Establishment Clause as opposed to expanding the free exercise clause. And that's also true in what I think is a less politically important case, although it got as much attention, the praying on the football field, because what they did there was they got rid of the Lemon test, which essentially is a test which worries about whether the state is going to appear to be endorsing religion, which all has establishment separationist kinds of concern. So again, this case is made much more easily of that, because assuming that this is private speech, and that's a factual debate in the case, but assuming it's private speech, it's quite easy to say that public officials don't generally give up private speech unless it's really quite strikingly disruptive. And indeed, that case gives the majority opinion, says he had a free speech right as well as a free exercise right to pray privately, and not, so long as he didn't force others to pray with him. So again, the key issue here is the Establishment Clause, and it reflects also kind of, my final point is a kind of division of labor between academic originalists and the court, because academic originalists like Philip Hamburger have been showing that the view of the separation of church and state is antithetical to the original understanding of the Constitution, and that is the background, and that's why the court can change, I think feels bold enough to change these and to go back to a more accurate and more modest view of what the Establishment Clause requires, which is not establishing a religion. And of course, at least if you consider his speech a private speech can hardly be thought to be establishing religion. It's someone's free exercise right. So these cases are, in my view, more about the Establishment Clause than the Free Exercise Clause.
Yeah, it's interesting. You mentioned this idea that there's a tension between the two religious clauses, and that's a really widespread belief that the two clauses are in tension with one another, and at times one has to give in to the other one. So it's interesting the way you highlight that really, if you're trying to cover all your Establishment Clause bases the way they used to be understood, and by doing that, you're telling religious schools or religious employees that they can't say certain things about God, really you're actually establishing more of a religion in that way, because you're setting rules about what can be said and can't be said about
so
God
the separation of power, the separation of church and state view, of course, puts religion at a disadvantage in public life. And that's, again, if we talked about this as less doctrinally and more of the place of this, you might worry that one of the real problems in modern life is and one of the dislocations of modernity is the difficulty of people to find kind of zone for their religious practice, a way that gives them a stability. And that's actually part of our instability in the modern world. And so one way of thinking about this is carves out more places for that, and energize perhaps the school choice movement in allowing people to go to religious schools. So it's very important, I think, in this respect. It's not a surprising decision. We've seen other decisions that were leading up to it, but the court, perhaps the most consistent area of this court is to reduce the scope of the Establishment Clause to something that approximates its religious original meaning. If you'll note, in the case about coming out of Maine about schools, the phrase "play in the joints," which is always about the tension between establishment and the free exercise, therefore we need to allow states to do various things that might otherwise violate rights, was there's a play in the joints between establishment and religion, the Establishment Clause. That phrase is used, I think, something like 7 times by the dissents and not at all by the majority. So it shows that they do not believe that there is a tension. Indeed, this establishment and free exercise are both about protecting the rights of religion and particularly religious dissenters. And in the modern world, you might think that almost by definition, religious exercise are somewhat dissenters from modernity.
So you mentioned the Lemon test there, and you also mentioned the distinction between private speech and public speech. One thing that comes to mind with especially the Kennedy case, we should have mentioned up front these two cases: Carson versus Macon is the school choice case, and Kennedy versus Bremerton is the football coach case. In the Kennedy case, this one especially makes me wonder about some of the other really well-known precedents. I mean, you mentioned Lemon seems to be gone. But also some of the other tests, the idea of psychological coercion, that was a really big thing in the 90s. You had like Lee versus Wiseman, where you had this idea that, hey, if somebody's up praying, even if nobody's forced to go along with it, they're nevertheless being psychologically coerced. The court here seems to want to have nothing to do with that. Are those sorts of precedents also?
I'm not so sure, because I do think it goes to the question of private versus public speech in the sense of you're an authorized. So I think I'd make a distinction between if you are speaking on behalf of the school, giving an invocation because you've been invited to a ceremony to give an invocation. I'm not sure the court would regard that as private speech. On the other hand, if you've been chosen as a valedictorian for other reasons, you haven't been chosen to be given an invocation, and you want to say something about God, I think that starts to look a lot more like private speech, and to say that you can't speak about God is quite problematic because you've been chosen to be a valedictorian. Someone might want to speak about something else, and you want to speak about how important God has been in your life at the school. So I think one key issue here going forward is trying to distinguish what private and public speech is, because I do not think the court is likely, outside of certain areas, historical areas like invocations before legislatures and things of that sort, I think the court might be less likely to expand that. Now, I'm not sure about that. You might say that, to go ahead about the Bruin case, which so focuses on analogies, they may say, well, this is more analogous to an invocation, which is surely public speech in a legislature. And so we should understand it in that way. That would, I think, be the kind of argument that would be made. So I do think it's open. I think it's not so much these cases, actually, that raise questions about Lee versus Weitzman, but about the kind of reasoning that the most originalist opinion, the Bruin opinion about guns, offers, and whether that kind of reasoning goes from the gun context to more general context. Then I might see a case like Lee versus Weitzman ripe for overruling. It's not, I think, from these cases themselves.
Okay, yeah, let's move on to the gun case then. Bruin, New York Rifle and Pistol Association versus Bruin. Here's a case you had McDonald versus Chicago, and before that, DC versus Heller, that had established the right, the Second Amendment covers a right to own a firearm, keep it in your home, and then, of course, McDonald applied that to the states. This case, the first one to really deal more with the bear arms question. So tell us about Bruin.
Well, Bruin came from the New York State. When New York State really has a rule that makes it, you have to have a special reason that you have had really threats against you that can be verified to be able to get a gun in New York State. And so there's great discretion in the ability to have a gun outside the home. And so the narrow holding, and the holding in this case is rather narrow. I think it's less interesting for its holding than its analysis, is quite simple that, well, if you have a right to bear arms, you can't have that. That can't be at the complete discretion of the states. That's just an impossible argument to make, and the various arguments, the various statutes at the time, which they looked at a variety of statutes, really didn't give the discretion to authorities to decide whether you could have a gun or not. And so, at its core, this case is very simple. You have the right to bear arms, and therefore the state can't inquire into that you have a particularly good reason. They might be able to say you're a felon or you're particularly dangerous, but you can't do that. And that's the core holding of this case. What's interesting about it is that they argue, and this you might say is more dicta in the case, but they talk about, well, what can restrictions be? And they say the restrictions have to be analogous to historical restrictions. That's the way. We're not actually going to look at some sort of tiers of scrutiny, which we see a lot in constitutional law. In other words, that we decide whether the state can restrict the right based on whether they have a compelling interest or a somewhat strong interest. That's not the way Thomas approaches it at all. And this is what is so destabilizing, perhaps, about law, even outside of the Second Amendment context. We're going to look and try to look at historical analogies. So one way of thinking about this in constitutional theory terms is Thomas is a long discussion of what is called the expected applications of the Second Amendment. Well, how was it actually applied? And we're going to try to make analogies to it here. So one issue is he does suggest that you don't necessarily have a right to carry arms everywhere because there were some restrictions, but those restrictions weren't so great as to make it impossible to carry arms. And so one question going forward is, I think, are these analogies going to be strong enough to come up with principles? So from these expected applications, can one draw lines of principles to answer modern questions? That's also true with respect to the kind of guns, perhaps, that you can have as well. So I think this case is really important. It's important because it does get rid of these statutes that give complete discretion to states to decide who can carry guns outside the home. But it's important in two other ways. It's important for the Second Amendment, suggesting that going forward, there's going to be a lot of historical analogizing in the Second Amendment to ask the questions that are left open by Brune. Well, what are sensitive places? What kind of requirements how far can you put requirements for people to hold insurance for guns, to go through a very intensive test of training for guns, which of course raise the cost of owning a gun. Those questions are left open by the case, and although what's not left open is the method of reasoning that courts are going to have to exercise. So that's important for gun cases. But more generally, it's important, well, what about other rights cases? Should we look at those cases through tiers of scrutiny, or should we look at them as more historically infused? And finally, there's a case about originalist theory, which I don't know how much your listeners are interested in. There's a debate in originalist theory about how people at the time thought the clause would be applied, how much that should matter to the meaning of the clause, as opposed to just looking at the dictionary, as looking at it as what we call more naked word meanings, and looking at how people thought it would apply at the time is what's called expected applications. This seems to be a very strong endorsement of looking at expected applications, not because expected applications constitute the meaning of a clause, but because they're some of our best evidence of how it would be applied and understood.
Right. That's the real connection, right, between this historical approach and a more text-based approach, is that you're saying, the court's basically saying, look at all these examples of laws that were passed around the same time.
To understand the text,
to
cash out the text of the meaning,
right. And
that tries to concretize the text. I mean, tries to move the text to be less abstract. So, because of course one move of a famous philosopher named Dworkin says, well, I can be an originalist if I interpret this at a high enough level of generality. But of course, it's great tension if you're interpreting a generality, but Thomas is saying, well, we don't want to look at things as so general. We actually want to look at how people understood it, and we'll look at it by these applications of theirs. So it's a completely anti-abstract originalism, and that, I think, is its most important effect for constitutional theory going forward.
Right. So there are, as you indicated, there are a lot of questions that still have to be answered in here. So I want to bring up Justice Barrett's concurrence, where she kind of brings up some of these important questions about history and how we think about history. She has two things that she says, well, the court didn't really have to do it here, but it's something we're going to have to figure out when we go forward. One is she says is how much can we consider history after ratification? Because a lot of these cases, and this is kind of previewing a little bit of Dobbs too, because Dobbs is very historically focused as well. They kind of come across as presenting this really sweeping history of
right.
American practice.
So I think this is interesting.
So yeah, go ahead.
Yeah, interesting. So how much post-ratification applications can make a difference? Because you might think that expected applications are important, but they have to be sometime around the time the clause has been done, not maybe right at the time, because you might think that the people who ratified it have some insight at how it was going to be applied for the next 20, 30 years. But what about 40, 50 years after that? It's even made a little more complicated in the amendment in the Second Amendment case, because the Second Amendment then is thought to be applied to the states by the 14th Amendment, which is in 1860. So you might think that evidence is relevant because we're still looking at it in the 1860s. So that's the question that Barrett is concerned about, because insofar as, let's assume for a moment, you just were looking at the Second Amendment as applied to the federal government, and so you weren't looking at it as applied to the states. So what relevance would some application in the 1840s have at all? That really wouldn't be originalism. That would be a different kind of constitutional interpretation called, I think, traditionalism. So we are going to interpret the Constitution as it's traditionally interpreted, not how it's originally interpreted. And there are some people who are sympathetic to law as tradition. I don't want to dismiss that, but that's not originalism. And I think Barrett's concurrence is reading between the lines of that, expressing concern about if we move off from originalism to tradition. And as I say, in the Second Amendment case, it's a little unclear, because the antebellum expected applications might be important because it's a state case, and actually what enforces the Second Amendment is the 14th Amendment, which is passed in the late 1860s, and so that becomes relevant. But I think that's the key question, and at the highest level of generality is, are we going to have a kind of pure originalist take on the Constitution, or are we going to have a originalism plus tradition take on the Constitution?
Yeah, those are all really interesting questions that they strike me. This is the case that when it first came out, I instinctively liked it, but the more I read it, the more I said there's some difficulties with this. It's what you brought up, that when the Second Amendment was ratified in 1791, it didn't apply to the states. So when you're looking at state laws, you have this kind of fuzzy gray area in between. The state laws are really reflective of these things, these state constitutional protections that the court talks about as state analogs that are kind of like the Second Amendment, but in the state constitution. So there seems like there's a kind of fuzziness there to me.
There's a fuzziness there that I think necessarily comes because you might not say what's the expected applications of the Second Amendment are irrelevant, because they probably inform people's understanding of the state constitutions.
Right.
So in this case, it's a particularly difficult area to draw the historical lines, but I think Barrett's right to express some concern about trying to make this a little more methodologically pure.
Yeah, so it seems like from this, one of the takeaways is we're probably going to have a lot of Second Amendment cases in the coming decades that try to figure out this some of these historical questions, but also filling out what you mentioned before, that the case leaves a lot of. It's a pretty narrow ruling, really. It basically says New York's system was very, very restrictive, and you can't do that. But it doesn't really tell us much about what sort of other restrictions are and are not permissible. It doesn't necessarily draw those lines. So we'll probably be seeing a lot of that.
We're seeing a lot of Second Amendment litigation. I think that's absolutely true. Although we'll do it in a different context, in a context which I think there's certainly a sense in this opinion in which lower courts have been grudging in their granting of Second Amendment rights. And I think this historical structure is to try to say, well, you just can't look at what people today are saying it's a good idea to restrict them. You've got to fit this into a historical analogy. So I do think it's certainly more friendly to Second Amendment rights than some of the lower court decisions after Heller.
All right, well, let's get to the big one then, the last of the big rights cases, and of course the one that everybody's talked the most about, the most influential, the one that's having the most political consequences, obviously Dobbs. I don't think we need to go too much into the detail of the facts of Dobbs. I think most of our listeners know what Dobbs is about. But just walk me through what exactly the court did here, how it managed the question of stare decisis with both Roe and Casey.
Key connected to its management of the stare decisis was it begins, and there's been this also true of the Alito's opinion in a case called Mcginnis about the First Amendment. His first view is the stare decisis now is this decision correctly reasoned? And if that's your first view, if that's your first take on stare decisis is going to become weaker because you're going to focus on how mistaken this decision was. And so what really animates this is Roe is just a completely poorly reasoned decision. And in that sense, he's pushing against an open door because even many supporters of abortion rights have seen Roe as terribly reasoned. And so that's, I think, the reason both tactically he does it, but also that it's a way of, I think, perhaps weakening stare decisis if you begin with that issue. And so that's really a lot of this opinion. It goes through the various arguments. So it can't be a variety of amendments. So the hardest issue is, substantive due process, which of course you might think is not an originalist idea. The way essentially as Alito deals with that, he says, well, maybe under privileges and immunities you could have rights, but the test for these rights, given in doctrine or perhaps in originalism, although he's less clear about that, under privileges and immunities is, are they deeply rooted in history and tradition? And abortion was just not deeply rooted in history and tradition. It's always been clear that substantive due process has had two prongs, it seems to me. One for sexual autonomy rights, which don't have to be deeply rooted in history and tradition, and other kinds of rights. And so now going forward, we're going to have one test for substantive due process. We're only going to protect rights that are deeply rooted in history and tradition and sort of crush outlier states that are really completely outside of American tradition. So that's what it means for the going forward on substantive due process. The other problem Alito has is other same-sex marriage, which I also do not think was deeply rooted in history and tradition. Even Griswold at the time, I'm not sure that was deeply rooted. What are you going to do? Are you going to overrule these cases? And he says no. And I think no for two reasons. One, I think certainly same-sex marriage, there's a lot more reliance on it. People actually are married. It looks a lot more like marriage is an economic proposition, among other things. So it looks more like economic rights, and economic rights generally get a lot of stare decisis because people have invested on the basis of that. And secondly, I think he tries to say, well, this is not as obviously badly reasoned because a potential life is at stake. And so how could you just cast that aside in your calculus on liberty? I mean, this is I think is in some sense connecting this up with an idea that goes back to John Stuart Mill as a way of distinguishing these precedents, is that there could be some harm. The whole debate about abortion, is there harm? Much less clear with same-sex marriage and contraception. And therefore, we can distinguish these cases as well and how egregiously reasoned they are. But certainly, with respect to same-sex marriage, there also are different reliance interests. And Alito says every case you have to decide whether it's overruled on its own stare decisis principles, including reliance. And that's how he makes quite clear that we're not going to see the court overruling same-sex marriage. I don't think we're likely to see the court overruling Griswold and contraception, because I don't see it's very likely that any states could very plausibly outlaw that. I mean, even at the time of Griswold, these laws were rare, and the Griswold case was a kind of sport case. These laws were disappearing. So there's no likelihood of that coming before the court.
Yeah, I mean, I noticed Alito, when he lists the factors that you consider, he gives 5 factors. It says you have to consider the nature of the court's error. This is when considering overturning a case that you think was incorrect. You have to consider the nature of the court's error, the quality of their reasoning, the workability of the rules that they imposed, their disruptive effect on other areas of the law, and the absence of concrete reliance. Those are ones where you think, from the perspective of Alito and most of the people in the majority here, when you're talking about a Bergefell or some of these others, that the first 2 they probably would be pretty skeptical on, but then those last 3 ones are the ones that are going to be
right. That's true. Although I think even with Obergefell, I think because of this kind of harm principle, they might not think it is quite as badly reasoned as Roe. So but I certainly agree. Reliance is the key issue for Obergefell. It looks marriage is, as anyone who's married knows, is an economic proposition among other things. So I think that is going to safeguard Obergefell.
So you brought up the question of substantive due process versus privileges and immunities. Justice Thomas's concurrence, he calls directly, and of course he calls for reconsidering Griswold and Lawrence and Obergefell, but he also, in the context of basically calling for a complete reassessment of substantive due process. And Thomas, of course, has a pretty robust understanding of the privileges or immunities clause of the 14th Amendment, which might be able to kind of capture some of the things that fall out in substantive due process. But I think a lot of our listeners, certainly me, we cringe at substantive due process. Right? It seems something that's utterly atextual, kind of the paradigm case of judges kind of making it up as they go along. So a lot of people like the Thomas concurrence. You didn't sound like you think there's much likelihood the court is going to move towards just completely.
No, well, maybe, but not in this case. Justice Alito has been in Washington. I mean, to both overrule Roe and to say we're going to have a new standard of privileges and immunities, which may raise questions about all sorts of other rights, that would be an explosion. That'd be kind of like someone who's been, for some of our older listeners, the Iran-Contra idea. So where you take 2 controversial issues, trading arms with Iran and giving money to the Contras, and putting them together, and you have an explosion in the Beltway. So I think there's no chance that someone like Sam Alito would do that. Now, that doesn't mean that over time we might see the court giving an opening to privileges and immunities. I just think it's hard to predict that. What I do think they've done is pretty much shut the door on using substantive due process for really many rights that would startle people. And I can't quite see what the list of rights that are likely to be newly granted on substantive due process. So I think in that sense, it closes the door practically with respect to substantive due process as something that's going to create a lot of tensions with state law, but it doesn't substitute the privileges and immunities. In any event, I think that would have been an imprudent course for the majority.
That would have been Michael Corleone at the end of The Godfather, just taking care of all family business on one.
I think that's a way of putting it, yes.
How does the historical analysis in this Glucksberg standard, so the standard that the court uses was developed in Washington versus Glucksberg, that says a right, in order to be conferred by the 14th Amendment, if it's not enumerated, has to be deeply rooted in the nation's traditions. How does that compare to the kind of historical analysis that we were just talking about in the gun rights case?
Well, I think it's different because it's not connected to how expected it would be applied. It was actually not saying, well, they thought substantive due process protected these things and this is how it worked. It's much more not originalist. That really is an example of law as tradition. There's a different view of law. Law is tradition. The courts are supposed to protect traditions. Sort of a backward-looking view, right? You might say that if this were really well applied, you'd protect a lot of traditional rights versus new understandings. And so it would be deeply conservative in that sense. That's, of course, the opposite of the way substantive due process has generally been used. Abortion is the sort of obviously opposite of a traditional right. But that would be the Glucksberg test. It would be, I think, it's a good example of law as tradition, which I think is a alternative to originalism.
And they do seem to be saying, right, the right has to be deeply rooted before the 14th Amendment was passed, right? So it's not something like we can deeply root this in the last few decades.
It's conceivable that a right could be, I'm not sure they make that distinction, but it has to be deeply rooted. I think deeply rooted would have to be for hundreds of years. So 100 years, it would have to be deeply rooted. I'm not quite sure they say it has to be rooted at the time of the 14th Amendment. They don't need to with respect to abortion, because abortion wasn't deeply rooted at the time of Roe.
Right. All right. Well, you had, thinking more broadly about Dobbs's impact, you had an interesting article at City Journal last week about thinking about how Dobbs helps us understand what kind of country we are, and kind of presents two visions of what it means to live in a constitutional republic, or maybe you phrased it, a juristocracy versus a republic. And you say both of the sides in Dobbs, and you bring in the other cases too, but I think specifically on Dobbs, both sides offer a clear view of what the American polity should be. You want to explain?
Yes, well, the dissent in Dobbs is sort of interesting, which you might have thought the dissent in Dobbs would have just said, well, we don't, like Casey, we don't necessarily think Roe is right, but we should just follow it as a matter of stare decisis. They actually suggest that Roe is right. And that, I do think, is a kind of juristocracy, because Roe, I think, remains unmoored from any text of the Constitution. And one's view, even when one thinks of substantive due process, it creates this evolving principles, a sword for the judiciary to change our polity itself. And so that's one side. I think there's a much more constrained side, which says, well, we're going to actually enforce constitutional rights, but they have to be textually in the Constitution, because after all, that means they had a consensus of the people behind them, or maybe if they are rooted in our history tradition, which again suggests a more modest view for courts, because really it's not the court doing the work, but this very deep rooting in history and tradition. And those are two very different views about the place of judges in society. And I was a little surprised by the dissent in that respect. In that sense, I think the dissent may be looking forward in that sense to really contesting originalism. So it's there have been moves, even of justices in their confirmation, to say we're all originalists now. But now, having looked at what's coming from originalism, I think there's really going to be perhaps a renewed attack on originalism frontally by judges and others. Of course, it's always being attacked in the academy. That's nothing new. But in public discourse, because I think the fear is, and this goes back to something I said before, is the original Constitution is not very friendly to left liberalism or progressivism.
All right. Well, speaking of what it means to be a constitutional republic, let's move to the last case on the separation of powers and the administrative state. This is West Virginia versus EPA. This is a case that seemed like it could have been a Chevron case like 15 years ago. They're talking about agency deference. Majority opinion didn't even mention Chevron. The dissent, I think, did. But instead, they used this relatively newly developed doctrine, the major questions doctrine, which seems to me is kind of a carve out from the typical deference that the court used to give. administrative agency. So explain this case in the
Well,
major
right. Well,
questions.
first of all, right. So I think this case comes out of is about the power of. So what the EPA wanted to do in this case, it just didn't. The EPA had a statute that said it could change the systems of and make them more less polluting. And what it wanted to do in this case, the way it wanted to do it was just not require new anti-pollution devices, but require them to subsidize green energy. And the question was, well, does this language mean that? And, well, maybe it could mean that. You might say, well, the court could have just said, it just doesn't mean this, and we're just not going to give deference. And there it could have done that. I mean, that would actually, because there really are what I call two major questions doctrines, which I separate out by calling major questions and really saying it major powers, which major questions is a carve out from Chevron. We're going to do the interpreting, and certainly the court does it in this case. But it says something else. It puts in a clear statement rule. One of the ways we're going to do the interpreting is Congress has to be very clear if it's going to make major changes to the status quo in our world, which would include requiring plants to subsidize other plants, which is major changes in our economy. That's, I think, the real important thing out of this case, because actually Chevron wasn't cited, I think, all this term. So the majority is not citing Chevron is consistent with what may be happening to Chevron, which is they're not overruling it, but it's sort of disappearing. But the key issue in this case is that they're saying, well, Congress, if you're going to do something major, at least major, you're going to have to be more specific about it. And that links up, I think, with the non-delegation doctrine, the idea that Congress really has to make the major decisions. Now, notice they're not really reviving the non-delegation doctrine in two ways. First of all, they're letting Congress, if Congress wants to say this, they can do it. They can, and they can do it in a vague way. They haven't actually said, well, this is too vague, even though it is pretty vague, what you can require other plants to do various things, to subsidize various things. Seems extremely vague, doesn't give very clear standards. Congress can still do that, at least it's clear about its vagueness, as it were. If it's clear that it's going about its objectives, but it has to be very clear about these objectives. And so that's, I think, this is a controversial decision because some people have complained, well, this isn't really textualist. They're actually making things up. But my argument, the argument I think in favor of this is a way of trying to enforce the non-delegation doctrine, or at least encouraging Congress to give it some consideration, because the court, for various reasons, has difficulty enforcing the delegation doctrine because the rules aren't very clear. Moreover, there's enormous precedent that suggests it hasn't enforced the non-delegation doctrine. So this is a way of trying to get better enforcement of the non-delegation doctrine through a clear statement rule. And we see clear statement rules throughout our law for doing these things. And you might say this is actually a strong area for a clear statement rule, because what a clear statement rule does is requires more deliberation in Congress. They have to be clear about it. And after all, the value we're enforcing is deliberation. That's the value that's being forced by the non-delegation doctrine. We want Congress to deliberate about important things. So if you think clear statement rules are legitimate, and they're legitimate because they nest statutory texts in the Constitution, this seems a very strong area for me for a clear statement rule. But that's what's important about it, and that's obviously important going forward. We've seen the court do this before in this term, actually. It said that OSHA, they need a clear statement rule for OSHA to be able to put a rule on about a general rule that you had to be vaccinated because this seemed to be about a public health matter, not about something that was peculiar to the workplace, and therefore Congress, because it would have such dramatic effects, has to speak more clearly. So I think the major questions, or I'd like to call it the major powers doctrine, because I think we already have a major questions exception to Chevron. We're not going to give deference to the agency. this says we're going to require Congress to speak very clearly. And so this surely has implications going forward with respect to the administrative state. And the administrative state, perhaps I just should say this, is one of the things that's going to be continually on the Roberts Court agenda, because in all sorts of cases previous to this term, the court has been changing the rules of the administrative state, because the administrative state is in some tension with the original idea of having separation of powers. And yet there's all this precedent for modern government. Modern government is administrative government. How the court is going to address the precedents and yet move the administrative state back to what it regards as a constitutionally constrained administration is, I think, going to be one of the fascinating questions going forward.
Right. Yeah. And it's also one of the issues you said it's going to come up again and again on the Roberts card. It's also one that Robert seems to be a little bit more firmly in the camp of the other so-called.
Yes, I think that's right. There, Roberts is firmly, of course, he writes the WEBA, he writes them. And indeed, I think in some cases he's joins the liberals strategically to put more constraints on the administrative state when the conservatives don't join him. So it's very, Roberts, I think, is playing a very long game with respect to the administrative state. So I see that as likely, playing out over a decade, a reformation or a counter, I would call it the counter reformation of administrative law.
You also mentioned too, just how you alluded to how this case kind of gets at some of our more fundamental questions about Republican government, and I just want to mention, we don't really have time to talk about it, but Justice Gorsuch's concurrence is really strong on that too. I think he made a good case for why moving in this direction is really important for the idea of a self-governing people. So he's the big objection to a lot of this movement is that, well, we need the administrative agencies to do these things. Congress just can't do it, right? Congress is this dysfunctional body, can't make these sorts of decisions. We need Congress to just, for the most part, push these things off to agencies. And Gorsuch makes a really good good statement against that.
Well, that's the question, and the question is Congress. So that, I think, is the argument that this is coming at a time when many people think Congress is dysfunctional because of partly political polarization. And the question is, will there be, the political science question is, will there become therefore enough pressure on Congress to do these matters? And I think that's an open question. Or then we're going to have to see some constitutional changes to the structure, because there are a few areas. I mean, immigration is another area where the Congress seems, at least so far, to have been unable to come up with anything. Now, that may be because they're always in the shadow of the administrative state. They're always waiting for the president of their party to get in. Let's not do the hard work of compromise, because our champion will get in and use the administrative state to get us all we want. And that's the danger of the large administrative state. Presidential unilateralism can abet polarization and actually reduce the incentives for compromise.
Right.
That's the large political question that I think lurks behind these doctrinal issues.
Right. Really, with Dobbs and with this case, it strikes me as the court kind of putting these issues back to the political branches and saying, look, I know you're not used to doing this sort of stuff, but you guys are going to have to do it. And same with abortion. You can think of our political class, the politicians are kind of raised up in a time where they can say whatever they want about these contentious issues, and they don't actually have to do anything about it. And now they're going to learn to do that.
True.
And here you have the court basically saying, look, Congress, you haven't been doing this in a long time. You better learn. You better start exercising those muscles. All right. Well, just to wrap up then, let's think to the future in the next couple minutes. So what comes next? Are big cases coming down next term? Are the things percolating in the circuit courts?
Well, the biggest case, and I think we should end on this, because I think it's the biggest case for next term, is the case coming out of Harvard and affirmative action. I think there's very little doubt that the court has taken this case to essentially reiterate what Title VI says, which is that there can't be preferences on the basis of race and gender. Grutter said, well, we'll need this for 25 years. I think that would be coming up in 4 or 5 years from now, so it's only 4 or 5 years earlier. But I think they're going to do that. And I think that's tremendously important for social life. Because I live at a university, and I think that has really changed the nature of the universities. Because when you admit people on different standards, it creates all sorts of other tensions in the university that I think are playing out. So I think this will be important. And this is interestingly a case where the Roberts Court is both, you mentioned Chief Justice Roberts not being on board with some of things this term, but again, I think he's very much on board with this. And unlike some of these other areas where Dobbs is that popular decisions, so from some polling, it's not that popular. The Second Amendment, when referendum happened on preferences, there's quite clear, even in a very liberal state like California, there's not enthusiasm for them. So here the court has the advantage of being on the popular side, as well as I think it will think on the textually based side, and I think it's likely to. So I think that will have enormous effects in American life, or enormous. Who knows whether there'll be? I think there will be resistance from universities, but how that will play out is, I think, as important as the administrative state, because I think there are two. Abortion is a very important moral issue, but going forward, the two big issues I think for America are first separation of powers issues about who governs, and that's of course about who issues rights and who must issue the rules of the administrative states. So I think that's a structural issue. But our most important substantive issue, as sadly as it has been for hundreds of years, is how we will deal with race in this country. The question of whether we'll have a racially balkanized, it's my view, racially balkanized politics is a hugely important one for America. So I see these as actually far more politically important than either the guns case or the abortion case. Although jurisprudentially, the guns case is fascinating, and abortion, of course, goes to an issue that is understandably, to many millions of people, an issue of moral importance one way or the other.
All right. Well, we'll see how things unfold. John, thanks so much for joining us.
Delighted to be here.
And thanks for listening.
Thank you for listening to another episode of Liberty Law Talk. Be sure to follow us on Spotify, Apple, or wherever you get your podcasts. Please visit our journal at lawliberty.org.